there's a major defense to a fraudulent lien. So now you've compiled your lien, you were as careful as possible, you've recorded the claim of lien. What happens now? You get a counterclaim against you for a fraudulent lien. If they're successful, here's the punishment. It is a complete defense, and this is under 713.31 as well, the same statute, is a complete defense to any action to enforce a lien under this part. And the court so finding is empowered to and shall declare the lien unenforceable, and the liener thereupon forfeits his or her right to any lien on the property. So if it's declared to be a fraudulent lien, you lose your lien rights. Also, so that's if we're raising it as just an affirmative defense. If I have a lien, I say it's fraudulent lien, that's a defense. And if I prove that it was a fraudulent lien, great, it's gone. Also, any person who willfully files a fraudulent lien, as defined in this section, commits a felony of the 3rd degree. I've never seen a state attorney who even knows what a claim of lien is. But it's out there. It's out there. I mean, technically what's supposed to happen is I'm supposed to turn this over to the DVPR. The DVPR then is supposed to turn it over to the state attorney, and then good luck. Again, I don't think they would even know what to do with it. Unless there's drugs or a dead body involved, I don't think they're going to understand what to do with a claim of lien. Defenses. So now, you got an owner. The owner's claiming you've recorded a fraudulent lien against their property. You got a claim of lien that either includes things it shouldn't include, it shows work that wasn't done, or it over-exaggerates the amounts. Well, here are your defenses to that. Minor mistake or error. Okay, let's assume that it's a $100,000 lien, and you guys have a dispute over about $2,000. 2%. Probably going to be a minor mistake or error. Nobody's going to go ahead and set aside that entire claim of lien. Let's assume you got a $4,000 claim of lien and you made a $2,000 error. 50%, you're looking more like that looks more like a willfully exaggerated amount. That's no longer a minor mistake. Okay? Next one is a good faith dispute as to the amount due does not constitute a willful exaggeration that operates to defeat an otherwise valid lien. So you say you're entitled to X, the owner says you're entitled to Y. You all are trying to figure out how much is owed. You got terminated in the middle, so you're trying to figure out and trying to work in good faith to figure out exactly the value of the labor, services, and material to lien for. It's not like you're asking for a final payment. You're asking for a final payment. You know how much is due. I mean, look, I finished. Okay, this is how much is due. It's very easy. It's very simple. But what happens if you get terminated in the middle? You get terminated in the middle, you're trying to figure out, hey, you know what? I got terminated right before my draw was due. I'm trying to figure out how much is due to me and what I actually furnished. That's a good faith dispute. Just because the owner says one thing and you say another, if the owner proves to be right, your lien is not going to get thrown out because that's going to be a good faith dispute. Now, there's a case out there that talks about that overhead and profit as a separate line item being included in a lien claim. Once again, that is not lienable by any stretch of the imagination, period. That's a fraudulent lien. At least that amount that's been liened for. So, again, just make sure that you keep everything out. So that would not be a good faith dispute. It would not be a minor mistake or an error because it's never going to be lienable. Okay? Damages. In the event that a counterclaim is brought against you for a fraudulent lien, just be aware that the damages, that the owner would be entitled to damages occasioned by the fraudulent lien plus attorney's fees. Again, whoever wins gets attorney's fees. It's to the prevailing party. Court costs, clerk fees, the amount of any premium for a bond given to take off the lien. And just want you to also know about this, that they're also entitled to an amount not to exceed whatever is deemed to be the willful exaggeration. Okay, so again, in my scenario, if it's an $80,000 fraudulent lien, you know, for instance, you only should have liened for 20, you lien for 80, they're entitled to up to that 80. And it's up to the court. Now, if you do everything right, we're on to the next page. This is just another, I just thought it was a funny picture because this is kind of common. This is what happens when the contracts start with the owners. It starts out as the original contract down below, the small contract with the, and then next thing you know, the change orders wind up eclipsing the original contract. So if you do everything right, maybe you get both of those boats. Next page. So we're done now with liens. I'm going to talk to you now about contractual provisions that I just want you to look out for. Just be aware and protect yourselves. Contracts that say that you're not entitled to lien, those are unenforceable. I strike them out. If they're not struck out, I don't really care because they're never going to be enforced anyway. You can still lien. Unconditional lien waivers, this is kind of like the same thing. Before performing your work, once again, those are unenforceable. Can't waive your lien rights prior to performing work. Any contract that says that contractor waives any right to lien on this property, those are unenforceable. You can strike them out, but once again, at the end of the day, it's not going to be enforceable anyway. Pay when paid clauses. These are clauses that say that usually an owner will enter into a contract with a general contractor. The general contractor then enters into a contract with all of its subs, and they all have the identical provision, which essentially works to this effect, that unless I am paid by the owner, I will not be paying you, that you assume the risk that the owner will be paying me and are relying completely on the creditworthiness of the owner and not me as general contractor. So do not claim anything against me, because unless I get paid from the owner, you will not be getting paid. I strike those out if I'm representing a sub. If I'm representing a general contractor, I put them in. Okay? They are enforceable, they are valid, but they are strictly construed. Some courts have struck them down. If they're written, they're very touchy on how they have to be written. If they're